questions.
Well, thank you. One small correction from this morning. I think I said in answer to your Lordship's last question about Table 17.
Yes?
But I clearly said they were all different species of contracts, and I think I slipped and said between contracting counterparties and FCM, they weren't actually. The signatories to the contracts I'm referring to was FAL. So they weren't funds contractually due to FCM.
Okay.
I was reminded of that over the short adjournment. So may I now come to the point that I promised Lord Justice Snowden that I would come back to, namely the NAV requirement. Can I take this in as quickly as I can, but in stages, please? So can I first of all take you to what's in the judgment about it? And that is in a number of paragraphs, starting please, paragraph 17. So the Lordship starts at the foot of page 120 in our file and quotes a section of the offering memorandum. I will take you to that section in a moment, and your Lordship will be pleased to know I don't have to go on reflection actually to the Articles of Association. The quotation finishes on the next page, but the last line of paragraph 17 is the judge's words, not part of the quotation. Could we then go to paragraph 76? This is a quote from the investment management agreement, which is expressed in slightly different language, but reflects what we've just seen in the offering memorandum. If we could then go, please, to paragraph 130, 130, page 142. Which sets out the requirements that I have then referred you to before, because I've referred you to paragraphs 135 and 136 on the next page. Just to remind you, 135, factor finding 6.7 relates to the NAV assessment requirement, as the judge called it, and then finally to 364. There may be others, but in the time law, those are the references we found in the judgment. Could we now then go to the offering memorandum to see what that says? Supplementary bundle 1, tab 4. Could we go, please, first to page 67? This stands in addition, obviously, to the passage I referred you to this morning. So, page 67, internal page 10, and it's the definition of management fee. If your Lordships would be kind enough to read through, well, the whole of it, although from little 2 onwards refers to what happens at the end of the fund. If your Lordships, unless I'm going too quickly, forgive me. Could we go then to page 72? The same tab. Without getting into it, unnecessary debate about the value of headings. Can we just see there's a heading there saying realisation of loans investments, application of realisation proceeds. So I think Your Lordship has seen this page before, because the penultimate paragraph relates to break costs, and I think the learned friend, or I did, has already taken you to that. But if you'd be kind enough to go with me to page 73, there is a paragraph at the top, and if Your Lordships would count down 6 lines, on the 6th line there's a sentence beginning in respect of each quarter. Reminding Your Lordships of paragraph 135 and 136, which I have been to before, of course. The learned judge found as a fact that each of the defendants had actual knowledge of those provisions of what he called the NAV requirements. And I would venture to submit that his description of it as a requirement was outside. Now, there was evidence before the court that Mr. Diallo had been involved in the quarterly NAV assessments. We recall there being documents in the documents bundle at trial of the minutes of those quarterly meetings where he took an active part in them. And they were, from memory, as envisaged, essentially run by Maples. Now, coming back to the point Your Lordship was pressing me on just before the short adjournment, arising out of that, if I gave the impression yesterday, before I had gone through everything else, that I was limiting any justification for paragraph 372 to the other paragraphs I referred to yesterday, I didn't intend that, and if I gave that impression, I do apologise for it. But the question is, was the judge entitled to take into account all of the evidence and all of the cross-examinations to determine what we see in paragraph 372? And I would respectfully say yes. What else might we look at other than the points I've talked you through already? Well, Mr. Atabi was not of the board. There was to be NAV assessments every quarter, as we've just seen. There had indeed been NAV assessments every quarter. While the investment advisory agreement is said to provide fees to FCM on a loan-by-loan basis, as you recall that fee structure that Mr. Elias took you through, that doesn't appear in the NAV quotations we've just seen. The NAV decisions were undertaken by the board, as I've said, with the involvement of the Maples director. In my respectful submission, that is quite enough against the history of everything else for the judge to have formed the view he formed in 372. I do understand entirely Lord Justice Snowden's point that, is it paragraph 332, has got the reference to constructive knowledge. 333, I beg your pardon, has got the reference to constructive knowledge, but I did address that yesterday when taking you back to 135 and 136, which actually supports an entirely different conclusion from the judge. And it is for that reason that I've focused on the NAV for this purpose rather than the cash requirement, the cash reserve requirement, where the only finding of actual knowledge was against Mr. Diallo. In respect of Mr. Diallo, of course, I could rely on that as well, but as I'm not seeking to differentiate between them, I don't have to go there. It is quite enough, we respectfully submit, for the judge to conclude that Mr. Taby had no authority and that they knew he had no authority, especially in circumstances where, as the judge found, he also had no authority to divert money to his own company. So I would respectfully submit that that is sufficient to resolve the concerns of Lord Justice Snowden on that aspect of the section of the judgment we were looking at before the short adjournment. In those circumstances, we commend to this court the proposition that, I must put this the right way round, I would commend to you the unnecessary proposition that we're right, but the only proposition I need to win on is that the learned friend can't show the judge was wrong. And I know I've not used precisely the language of appeals against fact, but your lordships will know what I mean by that. So in those circumstances, we respectfully submit we have a sound judgment which has taken, is rooted in an extensive analysis of the facts, extensive, detailed, and quite hard cross-examination on both sides. And I'm only going to mention this once, I'm not going to come back to it, but as a separate heading of response. But I would venture to submit to this court that the criticisms made of the time taken by the learned judge are unfair, and there is no material by which this court should be able to conclude that it was, as Mr. Elias said yesterday, a judgment created in chunks or at speed at the end or anything else. One simply doesn't know how it was put together, when, and so on. So there it is. And I've also made this point in passing, but let me make it at the end as a generic point, that it's not as if the judge took against somebody at the trial and has found comprehensively against them. What this judge has done is found for and against individuals at different stages of his judgment on different issues. And that, I would respectfully submit, as the hallmark of a judge who has addressed separate questions and addressed them properly. In other words, no one can complain that anyone's been whitewashed or given a blanket beating. It is the hallmark of a careful judgment. There are circumstances in which one would wish to see it phrased in a different way or expanded in a different way, but that is often the case, and we've provided you with a judgment in our skeleton argument of the wait and run from the white book as well. The starting point is that the judge will have considered everything he should consider, unless it can be shown he hasn't. And we would submit that if you take that as your starting point, he plainly has. The assumption here is borne out by the material, borne out by the result. So let me now, unless your lordships have any further questions of me on that aspect of it, I know I've taken time with it, but your lordship, Lord Justice Mail said yesterday to Mr. Elias' key point, there's no point in fussing about which of the various causes of action might apply if we start with that basic proposition vindicated. So it seems to me I've tried to reflect that as the court starting point.
Yes, thank you.
So let me now move on, if I may, please, to a number of headings which I have to go through. I will go through them as quickly as I can, but at this relatively late stage of the trial, the appeal, I will be, I'm afraid, as you've seen, we've set out our stall in our skeleton argument, so I will be commending that to you, and I do not intend to rerun what is there. So I'm going to try and do this at fairly high level. Fiduciary duties. So I'm going to start with Fimmel's fiduciary duties, if I may. So we've provided you with our answer to this in our skeleton in short order. What we thought we were facing on this appeal was simply an assertion that there were no fiduciary duties, read clause 13. We hadn't appreciated that there might be a suggestion that the scope of the fiduciary duties found by the judge needed to be reformulated or reduced or anything like that, but there it is. So we start with the proposition that the judge has found that the investment advisor would owe fiduciary duties unless excluded by contract, and that's judgment 455. And Mr. Elias, I think, accepted yesterday that this was correct as a starting point. So the question is then, were they excluded by contract? First of all, clauses 3 and 3.7, 3.7 and 3.8 appoint Fimmel as both agent and attorney, which is a supporting starting point we would respectfully submit for the proposition that they would owe fiduciary duties. 3.16, you may recall, said that the manager will have full power and authority to appoint as investment advisor and or to delegate the performance of its investment management under the contract to any associate, provided the manager shall notify the fund in writing as soon as reasonably practical of any delegation or appointment. And then it is responsible for any acts or omissions of its delegate, as if the acts or omissions were its own. Then we had clause 5.1 and 5.5 of that contract. And that's the one which is we see as being designed to resolve the potential for certain conflicts. And all we would say there is that that is drafted on the face of it on the basis that there will be fiduciary duties. Could we just have a quick look at that for a moment? This was the, I think, the first clause where there was an exchange between Mr. Elias and your Lordships. 5.5, page 13, sub-bundle 1. The manager will normally act as agent of the fund, who will therefore be bound by its actions under this agreement. None of the services provided under this agreement or any other matter will give rise to any fiduciary or equitable duties which would prevent or hinder the manager or any associate in transactions with or for the fund. So I think one of your Lordships put to Mr. Elias that if this was intended to mean what he wants it to mean, there'd be a full stop after equitable duties and the rest of the sentence would go. That is only consistent with there being duties. If we then go on to clause 13 on page 18, Court's very familiar with this language, we've looked at it before. Now, one of the questions my Lord Justice Snowden asked Mr. Elias was whether this agreement should be construed alongside the offering memorandum. And we've had a look at that. What we can find is a reference in Chitty 15-074, which itself refers back to a case called Sigma Corporation, which is a Supreme Court case. But it's slightly different, but analogous. It was looking at a complex series of documents, but as we read it, between the same parties. And the question then was whether you could look between one and the other to construe the one, and held undoubtedly that you could, because they should be construed as a whole, which sounds entirely logical. And we would respectfully submit that the logic of that here would apply, because although strictly, if you like, strictly speaking, there are two parties to the management agreement, one and a different party to the investment agreement, and the offering memorandum is for the arrangement between the fund and its preference shareholders. In reality, they should be read together because they're part of a fund arrangement where the investors are to be both benefited and protected. And the reason we feel able to say that, because although it's not strictly the same parties as in the Sigma case reported in Chitty, the parties that we're talking about, that is to say Fimmel and were it to be necessary FCM, are themselves embedded in the offering memorandum. So the manager is named, the advisor is named. The only one that isn't named, other than by status, is FMB, the placement agent. So we say if there are a suite of documents, the principle is no different. So then we have to address clause 13, and I think, as I understand it, the point that I'm meeting on this appeal is that we can make sense of this clause by deleting a comma between the word statute and law in line 3. In our respectful submission, that is an unhelpful way to go about it and not the right way. What we say, if we read clause 13 together with the basic propositions which tell us what the fund manager needs to do, and then 5.1 and 5.5. 5.1 was the conflict of interest clause. In other words, the reduction of the width of the fiduciary duty clause. Read it with 5.5, it would be very difficult then to say, in the light of 5.5, that 13 was to exclude everything wholly. So 5.1 assumes a reduction of the bandwidth of duty. 5.5 tells you what is not excluded. In other words, anything that would hinder or prevent the manager, and so on and so forth. We've just looked at that wording. And then we look at clause 13, and that should be read in that light. If we read them all together, then it becomes fairly obvious, if not very obvious, that they're not wholly excluded. And that is before we take on board Mr. Justice Knowles' point, which, if I may say so, we respectfully agree with, that's in parenthesis in the middle of clause 13, whether arising from the fact that the manager is acting as the fund's fiduciary or otherwise. So in other words, the only answer to that is we're to read that as if it was acting for the funds as the fund's fiduciary, but actually isn't. And again, we say that does some violence to the meaning. The commercial purpose of the clause, just to remind you of what we said in our written script, the commercial purpose of the clause is to permit FIML to act as the fund's investment manager and agent as attorney without breaching its fiduciary duties in specified circumstances, namely 5.1 of the conflict of interest. That's all it's entitled to do. So far as there are authorities dealing with headings, we've dealt with that, and I just as Mr. Elias did, I just commend what we've said in writing. I say no more about it.
I noticed that the phrase any applicable statute, comma, law or regulation is used elsewhere. I found it, for example, in clause 3.14b. I don't know whether that sheds any light on the construction or the utility of deleting a comma or treating this as deleted, but I just draw that to your attention just in case.
I think
and there are also references to applicable law or law elsewhere in the contract, which again may or may not have a bearing. I don't know.
Well, what one could draw from that is that it supports our submission and not Mr. Elias's submission, because on the face of it, statute, comma, law or regulation looks like a standard boilerplate phrase and not one that's been misused with an inappropriate comma. And therefore, insofar as one was construing it as a phrase, it should have the same meaning throughout the document. And secondly, if there are other clauses which have got applicable law, but without the garnishing of statute or regulation, that supports the same proposition. So, Rod, it's not a point I'd spotted, but we respectfully submit that it's wholly supportive of our position. So, the individual's fiduciary duties. This is a little bit more difficult. It's a bit more interesting in the light of the judgment. But the fund. Let me pick this up with the judgment, if we may, please. Can we have the judgment available to us whilst I walk through that? And start at paragraph 418. So we were asking the court to make certain findings 11.1 and 11.2. The judge said at 4.9419, and I think your lordships looked at this yesterday, that he was able to make finding 11.1 with an important exception. So just pause for a moment whilst you all just remind yourself of that. And then 11.2, unless I'm going too quickly, forgive me. So if we go to paragraph 420, he says, as to finding 11.2, I find the fund gave its consent to FCM taking steps on behalf of the fund in relation to the redemption of the facility. This consent did not extend to steps concerned to alter the destination of the fund in the interest of Mr. Churchill. C, the steps taken on behalf of the fund in relation to the redemption, including cash flows, were taken by FCM acting by three named people as its employees, save for those concerned to alter the destination of the termination fee in the interests of Mr. Churchill, Mr. Diallo, and Mr. Nuseibeh. These steps were taken by them. So that's setting up the proposition of a distinction drawn by the learned judge at trial between them acting within their employment and acting not within their employment, doing what they were employed to do and not doing what they were employed to do. And then, the little d I don't think matters for this purpose. Paragraph 423, he says, there is no question that simply by being employees of FCM as the investment advisor appointed by the investment manager, they had a relationship with the fund, let alone one of trust and confidence that was fiduciary in nature. The fund's relationship was with FIML, or perhaps with FCM. Then we've got 424, where he says it's tempting in the particular circumstances to reach a different conclusion at the point from which Mr. Churchill and Mr. Diallo Nuseibeh set about to alter the destination of the 1.1 million of the fund's money to their benefit. As the present case illustrates, that is the point at which the obligations of any relationship were not honoured, and the first question is whether there was a relationship, by which I think he means a fiduciary relationship. 425, academic opinion rightly challenges whether a conscious wrongdoer, such as a thief, is to be treated as a fiduciary. See, for example, Dame Sarah Worthington's academic work, which is in the bundle. I'm going to have a quick look at that with you in a moment. She says to treat the top of the next page, to treat the conscious wrongdoer as a fiduciary is only the start, because then the question of what fiduciary duties apply to that relationship arises. This in a context where the concepts of trust and confidence, and especially confidence, are not an easy fit. Can I pause there for a moment and see if I can explore in my own language what I think Dame Sarah Worthington is trying to get at there? Is that you cannot, and the words in the original Seeley formulation is, you cannot without more divine a fiduciary relationship with a thief. Because then you do get into the difficulties of saying when does the thief owe you a duty of, or any duty at all. The position here, of course, is that these individual defendants are not in that situation. So the individual defendants are in the situation where they are entrusted. Different question whether right from the start they were fiduciaries, which, as you know, is part of our respondent's notice, but they were entrusted as delegates of FEBL named in the offering memorandum to carry out tasks for and on behalf of the fund. And we've seen them in the course of this case, for example, the relationships with Burgess Salmon, the giving of instructions to Burgess Salmon. That's what they were entrusted to do.
So when you say they were delegates of FIML?
Lord, I didn't hear, I'm so sorry.
Sorry, you said they were delegates of FIML.
Yes, well, FCM was, I'm sorry, employees of the delegate of FIML, I should have said more accurately. Because FCM was an associate, i.e. delegate of FIML, under the arrangements.
That's rather the question, isn't it? Whether that makes a difference.
Of course, of course. But what I'm saying is the individual defendants, I'm respecting for the purposes of this submission that learned trial judge was correct to say no fiduciary relationship between the individual defendants and the fund to start with when they were performing their job as employees of FCM. So this is addressing what we say is the proper construction of 426. And we read it very, very differently from Mr. Elias. In fact, we could not read it with greater polar opposites. So he introduces, and we've looked at it, 43, 44, and 45. He then says there's academic opinion against treating a conscious wrongdoer as a fiduciary because of the confidence, the unease about fitting confidence in. It may be that the particular circumstances in each case require different answers. So let me just stay with that sentence for the moment. What we respectfully submit that sentence carries is this meaning that the academic opinion, Seeley through Worthington, does not mean somebody who's a conscious wrongdoer could never acquire a fiduciary relationship. There may be circumstances in which that does happen. In the present case, he says, it is when the fund's proprietary claims in dishonest assistance knowing receipt are addressed, that the legal ground sufficient for the present case is reached. We read that as meaning because the individual defendants acted as they acted, in other words, outside the scope of their employment, but nonetheless, where they had control over aspects of the fund's life and were trusted to have that control over aspects of the fund's affairs, that is sufficient, but the legal ground is sufficient for the present case. The legal ground is reached. In other words, we interpret that as being that when they stepped outside their role as acting in the best interests of the fund, which they must have done by diverting the sums, and in the absence of authority, that would be so whether they were dishonestly doing it or not dishonestly doing it. They had no authority to divest the fund of its own money. So they were acting outside the scope of their employment. The learned judge, we think, is saying that at that point, and for that reason, they became fiduciaries. Now, there are two issues to arise from that. One, could that be right as a matter of law? We respectfully submit, yes, it could, because there's no law that says it's wrong. And it seems perfectly logical that they are exercising the functions of a fiduciary, the key function that the Dame Worthington article makes clear, deriving from Seeley, is the function of control, even though most of us tend to refer to it as trust and confidence. But he says the key requirement is control. They had elements of control and were trusted to have elements of control, but they stepped outside the employment with FCM, which, according to the judge's ruling in respect of the first claim we made, that they were fiduciaries all along, then made them fiduciaries. So this is entirely respectful to the learned judge's judgment. We say he has clearly found fiduciary duties. Now, if we're wrong about that, you're left in the very odd situation which is the situation that Mr. Elias says we're in, but it seems to me not the right conclusion to draw. But when the judge goes on to find breaches of fiduciary duty, he must somewhere between page 198, page 81 and 83, or where precisely where it is, I think so. Yes, 83. So in the space of 2 pages, he's completely lost the plot. And with respect, that can't be right. There is no way in which there is any disjunction in this judgment which would support that proposition. So if your Lordship's looking for what I've just referred to, I think the finding in relation to the breach of fiduciary duty is 437.
What meaning do you attach to the opening words of the very next paragraph, 427? Because the judge says that although in these circumstances it doesn't arise, the fund then seeks a finding. I mean, if he had just found that there were fiduciary duties, the question of the application of clause 13 would arise. But he says in these circumstances it doesn't arise. Surely that's just confirming that 426 means that there are no fiduciary duties.
Lord, I would be on thin ice were I to say that there is nothing in this judgment which is overly consistent. But what that may be referring to, let me offer your Lordships an alternative. What that may be referring to, I can't say, of course, but it may, is the question that there were fiduciary duties not only in relation to the diverted son, but in relation to other aspects of the case as well. You may have had that in mind. But that looks to me, if you're looking for a mistake, that's the mistake. Because
so you say that we shouldn't assume that he loses the plot within 1 page, but he loses it from one paragraph to the next.
well, Lord, it's not entirely clear. Legal finding 11.14 is itself, I'm not sure, terribly helpful on reflection, but all it's asking is whether clause 13 in any way prevents a finding that there was a fiduciary obligation.
Yeah.
So
he says, since I found there weren't no fiduciary obligations, the question doesn't arise.
Well, I absolutely understand that. What he had in mind when he said that, what he had in mind was the meaning of legal clause 14, 11.4, I can't say, and I'm not going to try and guess. So your Lordships are left in this unsatisfactory, I accept it's an unsatisfactory situation, where there are elements of this part of the judgment which are not easy to follow. But the point about it is that the alternative is that when we get to let me just see where I might be right in hanging this on missing termination payment. If your Lordships go over the page to 432, halfway through, while I do consider, as explained above, that Mr. Churchill, Diallo and Nuseibeh did not owe fiduciary duties to the fund in respect to the missing termination payment, that's not because of clause 13. So here he is dealing specifically with the missing termination payment, and that is all. Now,
so that their fiduciary duties are circumscribed by the nature of a future misappropriation or the nature of a future.
Well, no, because he held that they'd done nothing wrong in relation to the missing termination payment. So if we're right as to the premise on which the fiduciary duty starts, then in relation to the other 2 parts of the claim, there was no trigger. So that is why we say the more logical conclusion to draw, which then gives effect to paragraph 437, is that he was, his paragraph 426, when properly understood, says that the legal ground sufficient for the present case is reached. Now, what does sufficient mean? It can only mean sufficient to trigger a fiduciary duty in respect of a conscious wrongdoer. That's all it can refer to. So if you start with the propositions we've walked it through, he says there is no question, go back to, if you would, for 423, no question that simply by being employees of FCM, that they had a fiduciary relationship, 423. And if you then go to 424, tempting to reach a conclusion that the point to which they departed, they might have a relationship. The first question is whether there was a relationship. Academic opinion says, and we know that academic opinion says, because I've quoted to you, a thief without more is unlikely to create a fiduciary duty because of the question of confidence. It may be that particular circumstances in each case will require different answers. In other words, in some cases, the legal requirement for a fiduciary duty will be met, and in other cases, it will not be met. In the present case, it's when we consider these other claims, in other words, we would say the facts going to those other claims, that the legal ground sufficient for the present case is reached, not the legal ground for the present case is not reached. So what we respectfully say he's saying there is that there arose at the point of their departure from their employed status, their employed purpose.
Well, usually when somebody says that it's tempting to do something, that's leading up to a conclusion that they're not going to do it. Now, in paragraph 424, he says it's tempting to reach a different conclusion at the point from which they set about to alter the destination, but that is precisely the same as the point at which they departed from their position as employees and started acting on their own account to alter the destination of the money.
Yeah.
So it rather looks as if in 424 he's building up to say, but I'm not going to find that they owed a fiduciary duty when they started to alter the destination. And then you say that he reaches precisely the opposite conclusion in a paragraph or two later.
Well, can I just expand on 424 in this way? I'm reading 424 with 425. So what he says is, it's tempting just to reach a different conclusion because all of a sudden they've acted as a wrongdoer. So that's tempting to find there is a fiduciary duty, but without looking as to why. Then if we go to 425, he supports that caution by reference to Seeley and Worthington. We know that caution is tempered because it says a thief or a thief without more is unlikely to give rise to a fiduciary duty. And then he says particular circumstances in each case may bring about different answers. In other words, he is then drawing on the without more. So in other words, if there is no blanket prohibition, stepping outside your employment may well place you in a fiduciary relationship if the other facts support it. And then he says, when we look at the other claims, the legal ground sufficient for the present case is reached. He wouldn't say that if my lord, he was building up to reject it by the 424 temptation paragraph. So what I'm inviting you to do is to read these paragraphs together, and the direction of travel is, we think, very clear. Now, I would venture to submit, and I mean this with the utmost respect, that the language isn't very clear, but the direction of travel is very clear. So the only thing, then we go across to paragraph 437, where we find the breaches. And those are not equivocated in any way. So
I missed that. Where did you say we go next?
Page 200, Lord, paragraph 437.
Oh, yes.
So So, in my respectful submission, if you put all that together, it doesn't lead you to conclude that page 200 is the error and paragraph 427 is the correct answer. It leads you to conclude that paragraph 426 and 437 read together is what the judge intended, and the infelicity is in 427. There has to be something about this which is infelicitous. It's either 427 or it's 437. And if I were to do a stand-back analysis and invite your lordships just to ponder this, which is the more likely, an infelicitous phrase, or a finding that someone's in breach of fiduciary duty, which he's just found doesn't exist? That if I was a betting man, which I'm thankfully not, I would venture to submit that the infelicity is in paragraph 427. Now, I could make that submission without the word sufficient. The legal ground sufficient for the present case is reached. That is not language that this judge would have used if he was concluding that the legal ground for in this present case is not reached. And more to the point, if he was concluding that the legal ground had not been reached, he wouldn't have referred to deriving support from other claims in the case. He would be explaining that how can you have trust and confidence when someone's stealing your money, or something along that line. What he would be doing was supporting the Seeley conclusion, the Worthington conclusion. He wouldn't. He's done precisely the opposite. So what he's actually said is, they weren't fiduciaries to start with. It's tempting to think that they immediately became one without thinking more about it. Academic opinion says I should be cautious about doing that, and I agree. I agree the caution. Different cases will produce different answers. In the present case, when you look at the facts, the legal ground is sufficient for the present case is reached. That must be the threshold for a fiduciary obligation is reached. Fast forward 2 pages to 437, then he gives you that there's a breach of it. So I can't deny that there's an infelicity of language in 427, but the appellant can't deny that there is not an infelicity of language in 437, but a complete something that's completely incomprehensible. And as a consequence of that, we respectfully submit that paragraph 426 should have the meaning which we have ascribed to it. So,
in 426, in the second sentence, which you place reliance upon, the attention is focused exclusively on the liability of somebody other than the person you say is a fiduciary. All those claims are either, the proprietary claim is irrespective of the action of the primary wrongdoer, and the claims in dishonest assistance and known receipt are secondary liability. Why then do you link that with the point that the point in time at which you say the primary wrongdoer fell under a fiduciary relationship? Well, why would the judge? I am struggling to make sense of the second sentence, not least because it just doesn't say what you would expect it to say if in fact he was finding a fiduciary duty, but it's not even addressing the liability of the primary wrongdoer.
Well, maybe precisely because of the reason that your lordships just noted, that it's not until you look at the others that it's right then to hold a primary liability on these defendants. I can only say
that's complete bootstraps, surely. The whole point about looking at the secondary liability of a dishonest assister or a knowing recipient is that both those only arise if there is a breach of fiduciary duty by the primary person. How can you bootstrap yourself up to say there is a fiduciary duty at a point in time at which a secondary party becomes liable, which will only occur if there was a breach of fiduciary duty and a fiduciary duty owed in the first place? It's just bootstraps, isn't it?
no, Lord. I think what I with respect to it is the the dishonest assistance claim is dishonestly assisted. That's the easiest one for me to tackle. It's assisting a primary wrongdoer. So the individual defendants would be having secondary liability in that case.
Yes, you can't be a dishonest assister unless there is a primary fiduciary.
Unless there is someone else who's a primary fiduciary. I agree.
Correct.
But that doesn't stop him saying, when we look at all that, I'm going to hold these three as primary fiduciaries as well. Look, your lordship looks puzzled at me, and I can't help the fact that this is not felicitous language. I cannot stand here, and I'm not going to guess, and I do not know what was in the judge's mind when he wrote those words. I do not know what assistance he was deriving from the reference to the three claims that he mentions when he draws his conclusion. I can't answer that. It's only speculation.
There are two separate questions, aren't there? One is what the judge meant, and we've got your submission that, in particular, the word sufficient means that he intended to hold that these were fiduciaries. But the second, and perhaps more important question, is whether he was right to do so. And on that, you do need to identify and defend his reasoning, don't you?
We say that if you consider facts going to other parts of the claim, in other words, everything I've talked you through during the course of yesterday and today, these parties were placed in a position where they had control. They meet all the tests. They had control. They were trusted. Confidence was placed in them. They were largely unsupervised. And they were doing so as the delegate of a fiduciary.
As the employee of a delegate.
Your lordship's quite right, because but they were doing so under that fiduciary umbrella. Now, what the judge has decided is that if they were remaining within the terms of their employment, then they would remain as, I'm going to use the word, mere employees. It's a little bit inconsistent with their case at trial that they were joint venturers in a profit share agreement, but I'll pass by that because you may at this stage of the trial think it's a bit of a jury point, but it is a bit odd. So the situation is, whilst they were protected, they were relieved of the obligation of being fiduciaries. So, but in order to vindicate this, I would do it the other way around. I would respectfully submit the right way to approach this is to say, if you ignore the employment status for the moment, just park that to one side, would they, on the facts, be considered fiduciaries? The answer to that is plainly yes. Because just as your lordship started with Mr. Elias yesterday, saying in circumstances where the manager, so I'm going up to the civil level, in circumstances where the manager was described as the manager of an investment fund with power to do certain things, unless excluded, you'd conclude that there was a fiduciary relationship. Now, in that regard, the qualification was unless excluded by contract. Here, the answer would be unless excluded by status. What's the status that would exclude the fiduciary duty? Employment status. That's the right way to look at it. So then, once they step outside that employment status by divesting the fund which they serve down that chain of contracts and statuses, once they step outside that relationship, they lose the protection of being mere employees. They then become somebody who has, if we enumerate it, has control over someone else's property, is trusted to exercise that control properly without supervision, and has then acted to divest the true owner of the property. That, on the face of it, looks very much like a fiduciary duty which has been breached. And the answer to your lordship's question, I would respectfully submit, is not to ask why one's created, but to ask why there wasn't one in the first place, if the judge is right. And why there wasn't one in the first place is because, in all other respects, all the components of fiduciary duty are present. but they're not fiduciaries because of their employment status. In other words, all that trust, confidence, control, lack of supervision, power, and so on and so forth, is all protected. But there are circumstances in which that protection can be lost, and what should have been, absent the protected status, their true status, then achieves its proper place. It's that logical.
So when did they become fiduciaries? Was it, as the judge says at 424, the point at which they set about to alter the destination of the money, which I suppose might be as early as December 2016, yes. Or was it some later point?
I would say December 2016. On the judge's finding, 2016 is when they decided, as we've seen, to divert. When they decided that they would not take the risk of that money going to the fund because of the potential dilution, the potential disadvantage to them. That is when they stepped outside. So to a very large extent, if I'm right about that, it becomes completely irrelevant in this case whether we're right in the respondent's notice that there's always been a fiduciary relationship, because for all relevant periods there was a fiduciary relationship even on the judge's finding.
Now, at December 2016, the termination fee had not been negotiated. So does it follow from your submission then that from then on they were acting in a dual capacity? They were acting as mere employees to bring about the early repayment and negotiate the termination fee.
Yes. But
at the same time, they were in a fiduciary relationship as to what they would do with any termination fee which might be negotiated.
Yes.
Is that the analysis?
Yes. And that may be what the learned judge had in mind when he was referring to the proprietary claims, dishonesty, and knowing receipt. In other words, what leads to that liability is what they did between whatever date he had in mind. He didn't say, so that I have to deal with. December 2016. We then picked the story up on the 10th of April 2017, the 30th of May 2017. We picked it up on the 2nd of June 2017 with the creation of the second cancellation notice. In a sense, I don't think it matters to the outcome of this legal submission on the facts of this case when that occurred. The very latest it would have occurred is the 19th of June. And it doesn't matter to me when it then occurred. It could be a scintilla of time. But my logic would dictate that it started in December 2016, when, as the judge found, and it's not a challenged finding, that they set about ensuring that the sum would be diverted. Now, but there is a powerful logic behind this. The powerful logic, as I say, and I'm only going to repeat it again only the once, is that if you remove the employment status out of it, all the hallmarks of a fiduciary duty are there. So what we're looking for is what, as it were, inhibits that ordinary application of a fiduciary duty arising. That's their employment status. If you like, that's their protection from that duty. At some stage, that protection can be lost. Now, I understand entirely that if you're in the situation of a simple thief who walks into your, walks in and takes money from your safe, you might sue him for all sorts of things, but fiduciary duty sounds a bit difficult in circumstances where you place no trust and confidence in the thief. But you might have given somebody your house key. You might have placed trust and confidence in them. You might have put them in control of your safe. Well, they would be a conscious wrongdoer when they opened the safe and removed your diamonds without your authority. And in a sense, that I think, I can't say for sure, of course, but I think that's what Mr. Justice Knowles was dealing with in his first sentence of paragraph 426. There may be particular circumstances, in each case will require different answers. Different answers to what? Question mark. Well, different answers to is there or is there not a fiduciary duty arising when somebody acts as a conscious wrongdoer. That's the question he's answering. And then he says, and I'm not only relying on the word sufficient, I'm relying on in each case, it may be that the particular circumstances in each case will require different answers. So he's saying sometimes there will be, sometimes there won't be, In the present case, it's when the funds, I'm shortening, other claims are addressed, that the legal ground sufficient for the present case is reached. That can only mean he has found that this is a fiduciary duty case which is not excluded from being a fiduciary duty case because of the Seeley-Worthington statement about conscious wrongdoers. Because that says a thief, brackets, without more, close brackets, is unlikely to be a category 1 fiduciary. But there is more here. The more here is all the hallmarks of fiduciary status were already there, and what we're looking for is why there wasn't a fiduciary duty, and there wasn't on the judge's findings because they're employment status. They're not entitled to retain that employment status when they act outside it. It's really that simple. So that is what we would invite your lordships to conclude. And I'm sorry, I cannot, I've thought about it, you might imagine, I cannot provide you with a comprehensive suite of submissions which lines up every word in this particular section, in particular the first sentence of 427. I can't do that, but I am strongly submitting that if you're looking for an infelicity, which it must be, I'm going to use that language for the moment, if you're looking for an infelicity, it is far more likely to be that than it is finding a breach for a duty he's declared does not exist. That would be very hard.
Right. Okay.
So let me move on, because I think I've dealt with that. I've dealt with it in a completely different order to the one I'd intended to, but that doesn't matter. So then, if I can just deal very simply with FCM, I'm sorry, I ought to say we've got, as you know, a respondent's notice that they were fiduciaries from the start. I'm just going to commend that script to you, if I may, because it's largely what I've been saying here. I don't think the difference actually on reflection very much matters if we're right, that the judge is right, that there was a fiduciary duty. And let me put it this way. If you are satisfied that the judge said two inconsistent things, which on Mr. Elias's case is clear, then I would respectfully submit that we should win and override what he would say is the infelicity, that the incorrectness of 426. That's the bit that's wrong. If Mr. Elias is right that you can't read 426 and 437 together, then 437 should win as a matter of law, and our cross appeal should therefore prevail. It's that simple. I don't need the cross appeal if you're with me that there was a fiduciary duty from any time from December 16 onwards to some satisfactory time before my client's money disappeared. So let me say no more for the moment about that. Now, in terms of FCM, we also, as you know, say that FCM owed fiduciary duties, and in light of the time, I'm just going to commend what we've said about that in our script to you. In principle, let me support it by one logical argument. If you've got a investment manager who has proscribed fiduciary duties, clause 5.1 of the management agreement, reduce fiduciary duties, unless there is a written fiduciary duty and reduction thereof back to back in his delegate, it is not illogical at all, as Mr. Elias was saying yesterday, that the fiduciary duty of the delegate should be wider than the fiduciary duty of the manager. Precisely because there is a contractual structure between the fund and the manager which regulates the duties. There is not a contractual relationship between the fund and the advisor which regulates the duties. So the point he was making yesterday, it's very difficult to see why that should be, because you then have a mismatch. In my submission, is not correct. So paragraph 41 onwards in our skeleton is the FCM. It's the FCM one, and I'm not going to say more about it than that, I don't think. So if we then move on, just forgive me for a moment.
Let me just ask this. You've now, as it were, identified three ways of putting your claim either dishonest assistance in FIML duties, or dishonest assistance of FCM duties, or breach of their own duties.
Yes.
So far as the claim against the individual defendants is concerned, any one of those is good enough for you, isn't it?
Yes.
Do they, other than the sheer joy of winning points, do they add anything if you win on more than one of them? Or is it just that any one is good enough and gets you everything you need?
Yes. Even a proprietary claim, if I win on that, and lose on everything else, it won't matter. So the point we made in our opening TLS is we've won on whatever it is, five claims, and Mr. Elias has to knock all five up. We've got those home.
And so far as Mrs. Diallo is concerned, she's in no better position because she's a volunteer. So if you win on the points,
simple volunteer. We say no more about it than that. So that is essentially all I want to say. So far as we've got a duty of care claim in there as well. I'm standing here. I have to say I would be logically surprised if that was the last man standing and I'd lost on everything else. But I don't want to concede it. It's there. So can I just commend the script to you?
Yes. Well, there is a point against you which Mr. Elias took, which is that it is illogical for the judge to find that there were fiduciary duties, but no duty of care, and that his finding on no duty of care should, as it were, have priority. And I know you're going to say the opposite, but I want to address the inconsistency.
I think yes. So if I have to press for a duty of care in order not to get tripped up on fiduciary, then I'll press for a duty of care. But I can't for the moment see logically that it's going to result in any different answer.
No.
But our duty of care is very simple. The principal question between us, I think, is whether the existence of a contractual structure which does not choose to put in a direct obligation between the individuals and the fund should eliminate a duty of care. There's law on that. We've made our submissions on it. It's not. There is no absolute answer to that question. It arises, as I've always recalled it, more in construction cases where you've got subcontractors being alleged to owe a duty of care to an employer, for example, missing out the main contractor. But there is no straightforward answer to that, and every case turns on its own facts. We would respectfully submit in this particular case, for all the reasons which we say will give rise to a fiduciary duty, or at least some of those reasons, there should be a duty of care as well. Taking Lord Justice Snowden's point that there is some sort of equivalence between an acceptance of an assumption of duty and an acceptance of fiduciary duty. But those are not express acceptances or assumptions, they are matters looked at objectively. So to that extent, we would say these should be lined up. But if for some reason, and I think this is where Mr. Elias's point breaks down, if I may say so, if for some reason the contractual structure inhibits a duty of care, I can't at the moment see why that contractual structure should inhibit a fiduciary duty, especially not in the circumstances emerging, we say, from paragraph 426 and 437 of the learned judge's judgment. In other words, if these people had no fiduciary duty and no duty of care, so long as they were behaving themselves as employees, the moment they weren't behaving themselves as employees, why shouldn't they have both? But if you're still as it were unpersuaded by a duty of care at that point, on what rational, logical basis I would forensically submit could there be any objection to a fiduciary duty arising in circumstances where all the features of a fiduciary relationship are in fact objectively present and have only stopped the person being a fiduciary because of the employment status? So there are those two differences. But as I say, if I have to have it, then I'll ask for it. but
yes, all right.
And who knows? I would be depressed beyond measure were this case to go elsewhere. But in circumstances where one can never tell what might happen, for the client, I'm not in a position to make a concession in relation to duty of care. but your lordships know that it's not high on my priority list.
Mm-hmm.
But the only reason I would very much like fiduciary duty.
Sorry, I may have missed it, but when does the duty of care arise?
We would say the duty of care arose at the beginning, and if it that's our primary case. So in other words, our primary case on duty of care is lined up with what is our cross appeal respondent's notice on fiduciary duty. In other words, right from the beginning. That is to say, the judge wasn't, with respect to him, right to say that there was not a fiduciary duty right at the start. Sorry. Yes, by right at the start, I mean when they began the relationship, not in December 17. So, Lord, to answer your point, that the reason I was relaxed about that in my submission was that if I'm right about Seeley-Worthington paragraph 426, and I'm right that the point at which the fiduciary duty started was December 2016, then I don't logically need it to have started earlier because it covers the period of time where the harm was done.
Strange that the assumption of responsibility, or as it's put in the authorities, the undertaking to act for, on behalf, or in the interests of another person, starts when, on your case, the employee steps outside the employment relation, outside the bounds of his employment relationship.
In a duty of care situation, as your lordship saying, I think.
In either.
Well,
or to put my lord's point slightly more tendentiously, the assumption of responsibility is made when you start to act irresponsibly.
I understand the tension. The answer to it is because what is it? In a sense, the answer to the two things is exactly the same. What is it that is preventing a duty of care arising in the first place? Because you are acting for the fund, you're using reasonable skill and care for the fund, you have duties towards the fund. And what is said is that it's contrary to the contractual structure. So there's an analogy there with the employment status. So once you step outside that, what otherwise would have been the duty of care that you accepted or assumed, but from which you have been protected by your employment status, goes. So it's not, it's the same point, if I may say so, that I've been trying to make in respect of fiduciary duty. It's not that it creates a duty. The circumstances which were permitting what would have been a duty not to occur is removed. So the inhibition on the duty goes. So that's the logic of why it should start. But look, our cross appeal makes it clear that it's right from the start, pre-17, pre-December 16. That's either right or it's wrong. I would very much like to win on breach of fiduciary duty, duty of care, or non-West Deutsche Bank proprietary claim, because I'd then lose on dishonesty. I'd rather I didn't lose on dishonesty. So there are two routes. So to that extent, picking up your lordship's remark, I was going to say yesterday, on Tuesday, it's been a long week. It's not entirely a case which depends on dishonesty. But my easiest position is to win on dishonesty, but that's absolutely clear. So may I now turn very quickly to proprietary claim, and just forgive me for a moment. I would respectfully, I'm going to have to sit down, otherwise my friend's not going to get any reply at all, and he's got some ground to cover, I imagine. There are two bases upon which we could have a proprietary claim, it seems to me. One is West Deutsche Bank, and that's, in a sense, parasitic on unconscious wrongdoing. And the other is a more simple claim, which does not require conscious wrongdoing. Now, let me deal with the second of those first, because I don't think the first should be particularly contentious. So the second of those, I'll do all this very quickly. I'm going to try and give myself 5 minutes flat, so forgive me if I go quickly. RFC repaid the loan, and I accept entirely that that discharged its debt to the fund. May I, with the greatest of trepidation, seek to qualify what Lord Justice Snowden was putting to me yesterday, that the fund then owned the money, then had the money, it was theirs. I think, respectfully submit, that isn't quite right, because it hadn't received the proceeds. Rather, the money went to its solicitors, and its solicitors held it on trust for them.
So who had the legal title to the funds?
I think the position is that it's a target in Redfern's bare trust, which then I think lines up with the target in Redfern's.
So the solicitors held the credit balance on their client account for the fund, which was the beneficial owner.
Yes, yes.
In equity.
Yes. So I'm not resiling at all from the proposition that it went to their solicitors and therefore discharged the debt from the football club. I was just very slightly and only mildly qualifying. I think what was a complete acceptance yesterday that the fund had the money, and they did in one sense, but not in both senses. They did in the equity.
So the fund has the beneficial interest in the money, and the solicitors have a bare legal title.
Yes, yes. I believe that to be right.
No, if you have a beneficial interest under a bare trust, I mean, how can you do better than that in terms of bare ownership? If you had the money in a bank, that would just be a debt, technically, but nobody would dispute that as being.
No,
Lord,
I wasn't saying it had any particular resonance to any submission. I was just literally qualifying what I'd said yesterday. Now, the cancellation notice was originally said that the money should go to IRL. So I think it's right to say that if the money had been paid pursuant to that cancellation notice on the Monday, as demanded, it wouldn't have gone to targeted red funds, which is a point that may resonate for earlier parts of our submissions. Now, so far as targeted red funds is concerned, the only quote I would like to ask you to refer to, and you don't need to turn it up now, is paragraph 436, letters A to C. 436 A to C. And what that says is the circumstances under which the solicitor can part with money from client account are regulated by the instructions given by the client. They, I'm coming off the quotation by which I believe it's meant the instructions. They refers to the instructions, I think. They are not part of the trusts on which the property is held. I do not intend to cast any doubt on the fact that monies held by solicitors on client account are trust monies, or the basic equitable principles apply to any breach of trust by such solicitors. The basic equitable principle applicable to breach of trust is that the beneficiary is entitled to be compensated for any loss he would not have suffered but for the breach. Now, the individual defendants, on the judge's findings, and this conclusion is not the subject of appeal, were not authorised to instruct Burgess Salmon to bypass the fund. I've made a note that you may want to cross-refer there, and I'm not going to take a second to look it up now, but to paragraph 419 of the judgment. But it seems to be absolutely unquestionable that the fund, on the judge's findings, had given no authority for that instruction to be given. Yes, it is 419. The judge said, the last sentence, communications reports concerned to alter the destination of the termination fee in the interests of Mr. Churchill, Mr. and Mrs. Diallo and Mr. Nuseibeh were made by Mr. Churchill, Mr. Diallo and Nuseibeh acting on their own behalf. So very clear, not appealed. So what we say arises from that is that the instruction by Mr. Nuseibeh was not given on behalf of the fund, and we would say that would give rise to a technical breach, using that word. I think that's the way to put it, a technical breach by Burgess Salmon. In other words, they, in fact, as solicitors, were entitled on the face of it to act on Mr. Nuseibeh's instructions, but his instructions were false instructions. They weren't authorised instructions. So they got no liability per se. They couldn't be sued in negligence. But the instructions not being part of the trust, the instructions have then come from somebody who is not their beneficiary.
So are you saying the solicitors acted or did not act in breach of trust?
I'm saying the solicitors, I think, in those circumstances would have acted in breach of trust. If anyone sued them, they'd be entirely relieved of liability, and if someone sued them in negligence, the claim would fail.
Well, the point rather is, I mean, if they were sued as the solicitors were in Target, on the basis they had to reconstitute the fund, even though nobody had actually made any loss at the end of the day, then that claim would no longer succeed, because the test of for equitable compensation and so on is now based on establishing a loss, rather than the old-fashioned concept of reconstituting a trust fund in a situation where you have a bare trust.
I take your lordship's point, but it would still allow us, it still allows us in this situation to say that there was a breach, or we can say there was a transfer without consent.
The solicitors might say that Mr. Nuseibeh had ostensible authority to give the instruction.
I agree. That's why I say I don't think they could be sued. I don't think they could be sued in negligence for it. They would say, well, we acted properly. But there would in fact be a breach, I think, because they hold the money on behalf of the fund, and no instruction from the fund has gone to them to give it to FCM Cayman or to IRL.
But the instruction has gone from the investment manager. Sorry, it's gone from the the delegate of the investment manager.
Yes, it's gone from the employee of the delegate of the investment manager, but without the authority of the fund.
But ostensibly on behalf of somebody duly authorised to act on behalf of the fund.
Yeah.
And that's a breach of fiduciary duty by the solicitors, you say?
We would respectfully submit yes.
When they act in accordance with it.
It would be, I called it a technical breach of trust, because they hold no proper instruction to divest the fund of that money. So I've now gone over my time limit. So all I'm going to commend to you is the tab 34, as I've got it. The tab 37 is where you'll find the Worthington article. Can I just, for your assistance, give you 3 page numbers, going back to that point? The 3 page numbers are, these are internal page numbers of the article: 155, 159 and 160, and again 163. And I'm just going to leave you with the transfer without consent point, which we say is set out in Grant. We've given you the reference to Grant in our script, and I'm not going to go to it now, but it's 23-036. There's a point I want to make, and I'll make it in 30 seconds. That if we're wrong, and there's no breach of trust here at all, in other words, nothing that is a proprietary claim against Mr. Nuseibeh or his colleagues, because he was giving instructions on behalf of the fund to divert the money, that would be contrary to the decision of the judge, that he had authority which he didn't. It is also difficult to see in those circumstances how the court could regard him as anything other than a fiduciary. So there we are. Lord, that is all I wish to say. All I've got time to say. Thank you very much indeed for your patience.
Thank you, Mr. Jones. Mr. Elias?
Thank you, my lord. I do have a few points in reply. I would first like to address, or just say a little bit more about the net asset valuation requirement, assessment requirement, as it's been called. My learned friend this morning took you to places from where the judge derived his support for finding that that was in fact a requirement of the fund. And you saw that it was in the offering memorandum in 3 places, one which simply said that the auditors would carry it out quarterly, and there were 2 places where it was suggested that it seemed that such an exercise would be necessary. It would be a sensible thing for any fund to do that had to determine what excess it might have. It did not, of course, say this is a condition precedent to the paying out of any management fees. And it was only obliquely described in that offering memorandum, which is no doubt why the judge did not find that each of the individual defendants actually knew that such a process had to be carried out before any management fee could be paid. And just to remind your lordships of points in the judgment where the judge addressed that, it was at paragraph 57 where he held that the individual defendants were at all times familiar with the offering memorandum. It was at paragraph 135 to 136 of the judgment. And this is where he makes the finding that Mr. Diallo was in fact aware of the term of the offering memorandum requiring any termination fee or prepayment fees upon early repayment of the loan. So was aware of the term of the break fee clause. I'm not sure my learned friend is really pushing the point since that only applied to Mr. Diallo, but you will recall we saw a little extract of cross-examination where Mr. Diallo explained how he understood that clause to work, i.e. in relation to each investment. There was no finding that the judge did not find that he understood that clause to mean that the termination fee would have had to be retained in the fund. In terms of the factual finding 6.7, the judge finds that the individual defendants were in fact aware of the terms of the NAV assessment requirement in the offering memorandum. Once again, being aware of a term is not the same as actually understanding what it means. And that's particularly the case here because of the very oblique way in which the term appears in the offering memorandum, which you were taken to this afternoon by my learned friend. Paragraph 6.8, simply, this is the finding that the claimant sought, is that the individual defendants ought to have known about the NAV assessment requirement. And 6.9 is that they had constructive knowledge of the NAV assessment requirement. So that doesn't really take us very much further in terms of what they actually knew. And indeed, one might say that these paragraph, one more point, I'm sorry, judgment paragraph 334. Again, the judge reiterates that the individual defendants had at the least constructive knowledge of the break fee clause and the NAV assessment requirement in the offering memorandum. So there are various ways. I'm sorry, my lord.
I was just going to ask. It's curious. Although separated by 40 pages in the judgment, these legal findings that are dealt with in paragraph 135 and 136, namely factual findings, the findings 6.6 to 6.9, and 6.10, which is what's dealt with in 333 and 338, presumably all appeared together in the finding document.
They were set out in the claimant's closing submissions. I think right at the start there was a table of findings sought.
Do we have that?
Yes. Let me take it to it.
So it's it's the they were presumably all set out together, though, weren't they, or were they split?
It's in the. I think they're all together, but let's have a look at it.
My recollection is they're all set out consecutively at the start.
It's in tab 30 of the supplementary document.
So it's just slightly curious that the judge separates. Well, first of all, I'm not entirely clear. I understand exactly what the logic of those clauses is, or why the judge dealt with them in a very different way.
So if you turn to tab 30, page 445 of the supplementary bundle, and you can see that starting on page 446, the claimant identifies issues the court is required to determine. And then starting at 449, or with some introductory words on 448, these are the factual and legal findings in respect of each issue. So that's how they appear.
You say when you read these, that 6.7 simply relates to awareness of the terms rather than the meaning or import or consequence of them. And that's what's dealt with in 6.10, which is 333338.
Yeah, so in 6.10, they still say, judge still finds that they had any, at least constructive knowledge, but nowhere does he say they had actual knowledge of the NAV assessment requirement and understood that it meant that these monies had to be subject, it was a condition precedent,
Well,
they had to be subject to.
You say that, yes, they had no act, the judge doesn't actually find, by reference to these paragraphs, that the individual defendants had actual knowledge of the consequences of the break fee and the NAV assessment.
That's right. Yeah. And in particular with the NAV assessment, because it's so presented so obliquely in the offering memorandum, I'm saying that that's not a leap that could remotely safely be made, given that it requires construing 3 different clauses or parts of clauses within that memorandum. It doesn't set out expressly, clearly, as one might imagine, as one might indeed infer from reading the judgment, where it's presented as this very clear defined term, that somehow it sets out simply to be read that no payment to the manager shall be made unless or until X has happened. And in relation to the...
Was that distinction drawn below? Was there any evidence or suggestion that although they knew that the term was there and what it said, they didn't understand what it meant?
Well, my lord, we looked at the cross-examination of Mr. Diallo in relation to the break fee clause when I was on my feet earlier. And in that respect, there's some cross-examination which shows that Mr. Diallo's understanding of the break fee clause was not the same as that advanced by the claimant. He said, my understanding is it can be paid out on effectively an investment by investment basis. So if the principal of a particular investment isn't repaid, then you wouldn't be able to take the fee. But if the principal on the particular investment is repaid, then you could. And of course, he then referred, you may recall, to the fact that the administrators in 2019 appear to have adopted the same approach, he said. I don't have in this bundle, and I'm afraid I can't say categorically whether the individual defendants were cross-examined or whether it's specifically raised in relation to the NAV point. But this does bring me on to my next point, which is that the way in which this matter arose, which seems to have assumed some central importance now, is that the requirement for an NAV assessment does not appear in the particulars of claim. There's no pleading that the individual defendants knew that an NAV assessment had to be carried out by the fund before the fund could pay the management fee, which, given the way that my learned friend now advanced his case, one might have thought was a central pleading. There's no pleading that the individual defendants were dishonest in depriving the board of the opportunity to conduct an NAV assessment requirement before paying out a management fee. And this seems only to have arisen, in fact, in the claimant's RFI response. And if I can take you to that, please, which is in the core bundle, page 274. Sorry, that's not the right place. It's the core bundle 329. I'm sorry. At tab 21, this is further information from the claimant, so provided by the claimant. And the answer to request 1, you'll see that it's said to arise from various paragraphs of the re-amended defence. So unusually, this is not, there was no reply. So it seems that this is not asking the claimant to clarify the claim as put, it's asking it to set out its case in matters, respective matters raised in the reply. Then there follows answers on various different matters put forward by the claimant. And on this point, paragraph 10, it says, sorry, this is under the heading on the previous page, 328, diversion of termination fee payment, breach of contract. And at paragraph 10, it said, even if it's held that the termination fee payment, had it been received, would have constituted net income of the fund, which is denied, the fund was not entitled under the offering memorandum to agree to a diversion of the termination fee payment without first undertaking a formal account of the fund's financial position, a mechanism in place to protect investor shareholders. This was not done. The offering memorandum provided on page 10, and these are the parts my learned friend showed you earlier, the section entitled Management Fee, page 16, section entitled Realisation of Loans and Investments. And then also on page 26, where there's the reference to the administrator, Maples, carrying out an NAV pursuant to its administration agreement with the fund. So this, even in this RFI response, which of course is no proper place to set out your case, set out fundamental matters such as allegation of dishonesty. But even here, in fact, it does not. It says that the fund was not entitled to pay out the money, but there's no allegation here either of the defendant's knowledge of this, and no allegation that it was an aspect of dishonesty. I should also refer you to answer 12, point 12 on page 330, where we just got to. And this is in relation to the heading no ostensible authority. So where one has had ostensible authority. And they say the defendants cannot rely on any usual general authority they claim Mutaz had to act on behalf of the fund, because the individual defendants had actual or constructive knowledge of the terms of the offering memorandum, and therefore that it would be a breach of the fund's contract with its investor shareholders for the termination of fee payment to be diverted away from the fund, at least before an NAV calculation had been undertaken by Maples. So we do say that if one looks at the particulars of claim, this is not pleaded as an allegation of dishonesty.
Was this point taken at the trial? And effectively, the pleading point, it wasn't open to the judge to make these findings? I'm sorry, of course, I know you weren't there yourself. With the wisdom of those behind you, perhaps. I mean, it's going to be quite important if you're really asking us to decide the case on a pleading point.
I wouldn't be asking you to decide the case solely on a pleading point, but I am saying that this goes to the point that if it goes to the general point, which I'm going to come on to, about the way in which dishonesty has been advanced in this case. So I do say it doesn't seem to have been pleaded, that particular point. And moving on to a more general point about dishonesty, you may recall yesterday my learned friend made various submissions about what you might call the broad brush sweep of what he called the scheme involved. And at one point he sought to suggest that the individual defendants were involved in a dishonest scheme because they sought to deprive FMB, Floreat Merchant Banking, of a fee. And that's also an unpleaded matter. And in my submission, when one looks at the NAV assessment requirement and one looks at the way in which it was being advanced yesterday, this is an example of what we might call the protean nature of the claimant's allegations of dishonesty. Now, in relation to FMB, I would also say that's wrong in any event, because it was up to Mutaz, as sole executive director of FIML, and sole shareholder indeed, to decide what fee he would agree should be paid to, or perhaps on behalf of, or in relation to, in some way, FCM Cayman. And what's more, the amount of the fee paid to FCM Cayman did not affect, in any contractual way, the amount of the fee that would be paid to FMB. You may recall when we looked at the investment advisory agreement, it provided that the fee which was to be agreed between them was to be paid out of the management fee received by FIML, but there was no such provision in respect of the placement agency agreement at clause 6.1, that's at S50. So in other words, it doesn't even follow that if a higher fee is agreed to be paid to FCM London, that Floreat merchant banking would necessarily receive a lower fee. So we say that that's a point that is not open to my learned friend to take, but it is in any event a bad point. I can say in general terms at trial that Mr. Cavender, King's Counsel, objected that dishonesty allegations were being advanced that were not pleaded or put to a witness. And he makes that, and that objection is recorded in the judgment at paragraph 379. So it was certainly a point taken in general terms. And then at paragraph 380, the judge says, I've had careful regard to the instances to which Mr. Kavanagh QC drew my attention. But where appropriate, I have confined myself to the case as pleaded and had close regard to what was and was not put to the witnesses. So that's what the judge, he says he's confined to.
I know that's what he says, but I mean, that's the problem is, without chapter and verse, it's very difficult to trace how he complied with that.
But what I can say is that certainly, as far as I can see, my learned friend will no doubt correct me if I'm wrong, but I can't see there's any relevant pleading to do with the NAV assessment in the pleading. Mr. Cavender at trial made an express protestation in closing that matters were being advanced that weren't pleaded, and the judge said, well, I've confined myself to the pleadings. So it seems to me that proper objection has been taken at trial to the fact that the judge shouldn't rely on anything that hasn't been pleaded, and the judge seems to say that that's what he has complied with, or at least it seems that's clearly what he's intended to do. But to the extent that, my lords, you now find that the NAV assessment requirement and the individual defendant's knowledge of it is an essential aspect of dishonesty, or an essential aspect of this case, then in my submission, it hasn't been pleaded. The judge shouldn't have found dishonesty on that basis. It's another reason in my submission that undermines the judge's findings of dishonesty.
Well, you say it's not pleaded in the right place, but I mean, it is pleaded, isn't it, in the further information you've just taken us to?
It's raised in further information. It's not pleaded as a particular of dishonesty.
I mean, perhaps we do have this problem. It doesn't look as though any pleading point was taken with any great vigour with regard to specific allegations. And if that is the way the trial was run below, and there may have been all sorts of reasons for that, it might be inappropriate for us to adopt a very pernickety approach, as one might in many cases where dishonesty is an issue, provided that the material was at least in the arena via the RFI, and was the subject of cross-examination of witnesses and consideration by the judge, who himself was aware of the need for allegations of fraud and dishonesty to be fully pleaded, and said he wasn't going outside those parameters.
Well, my learned junior can perhaps find the place in our written closings where this point is made, but
yes, I mean, I've somewhere seen something perhaps at the beginning, or separated from the written closings, as a separate note, or a sort of grumble by Mr. Cavender.
There is. So if one, it's in the supplementary bundle, and the defendant's written closings are at tab 31.
Yeah.
And right at the end,
That's right. Yeah. 639.
there's a note on C's. Thank you. There's a note on C's written closing.
Sorry, where are we? I was looking at something else.
I'm sorry, we're at bundle S 649.
Right.
Sorry, 639. This is note on C's written closing. So he makes a general point that the claimant advances allegations of dishonesty that are not pleaded. And he says at paragraph 3 examples of these issues. So he doesn't purport to set out a comprehensive set. So and the examples under unpleaded allegations of dishonesty and matters that are not put to the witnesses. There are only 2 in respect to unpleaded allegations of dishonesty, and I obviously have to accept that this isn't a particular point that he takes. It may not have appeared at the time that the non-compliance with the NAV assessment would assume anything like the importance that it seems to have done in the judge's reasoning. But he does squarely raise the fact that allegations which are not pleaded should not be the foundation for findings of dishonesty.
Paragraph 9 seems to relate to the NAV and the...
Yes, I was going to comment on that. That's a specific point saying that Mr. Churchill in particular, it wasn't put to him.
But was it by inference put to the others?
Well, I would have to accept that that's the reasonable inference to draw, of course.
Well,
as your lordships will know, at the end of a trial, when one is trying to, especially it seems a trial such as this, with many, many different factual matters in play, I'm afraid I'm not in a position to say whether it was expressly put to the others. He's clearly noticed it wasn't put to Mr. Churchill.
I think the judge doesn't deal with the evidence on the assumption it's not in the pleading. The judge doesn't deal in the judgment with the evidence that was given at trial about the belief of any of the defendants as to the NAV or its relevance.
That's my first point. That's why I started there, saying actually I don't think he makes the relevant findings. So I make this point that it's not pleaded as a secondary point to say that it wasn't pleaded, it was an objection taken, at least in general terms, at trial. In terms of Mr. Churchill specifically, there seems to have been a further point that it wasn't put to him in cross-examination. But I think it's enough to say that he doesn't actually make the findings of actual knowledge that the 2-stage test for dishonesty requires in respect of this particular point.
So, yeah. So at very least, if this wasn't put to Mr. Churchill and wasn't pleaded, you say it couldn't form part of any finding in the judgment.
But I say it shouldn't form part of any finding. The fact is the judge goes on to consider it anyway, and even so, he doesn't, in fact, make a relevant finding of subjective belief of the 3 individual defendants. And although, interestingly, he separates out Mr. Diallo in terms of being the only one who knew about the break fee clause, he doesn't separate out Mr. Churchill's knowledge in any way, but it may be he thought, well, there's no need to, because it's not a finding I'm making, that he actually believed that this was the consequence. Also, in respect of dishonesty, my learned friend said repeatedly that the judge had found that the defendants knew that Mutaz did not have authority to deal with the termination fee. And I'm sure your lordships are fully aware of this, but of course that's, in my submission, far too great a simplification of what the judge actually found at paragraph 372 of the judgment. Just to reiterate my point here, the judge found, or said, they, the individual defendants, further appreciated that Mr. Mutaz al-Taibbi's authority, considerable though it was, did not extend to allow him to treat assets in the fund as his own, to apply to his advantage, or give away for his own purposes. And my submission is that that is a finding that they did not believe that he could give away everything that the fund had, which would include all the investors' investment money, and indeed their 5% dividend and everything else. But in terms of a finding of dishonesty in relation to the diverted sum, the relevant question is surely what they believed his authority was to deal with that. Because as our Justice Snowden was saying a moment ago, it's a very different question when one comes to the objective test. It's one thing, did they really believe that he could do anything at all with the money, give away the investors' money? Well, it's unsurprising the judge should have reached that conclusion. Of course, they would not imagine that he could simply leave the investors completely high and dry at a whim. It's a completely different question to say, here is a sum, which we also say they believed, ought to be paid to Fimmel. It was a management fee, it was profit. It wouldn't cause any harm to the fund because the fund was never going to hang on to it. We've seen lots of evidence about that. Did he have authority to deal with that? That's dealing with a sum of money which, as they all understood, would never actually harm the fund, wouldn't harm the investors. And of course, we've seen that's exactly what in fact happened in 2019. And as we've seen in 2019, the administrators paid out the sums received in short order. They paid it out towards the end of June. They didn't even wait for the end of the quarter. There's no sign they conducted a NAV assessment. And it went every last cent to Fimmel, exactly as the individual defendants say they believe would have happened if the termination fee had been paid to the fund in 2017. Mr. Jones, in my submission, didn't really grapple with this issue as to the relevant finding found by the judge. He said a couple of times that the judge must have had in mind when making this finding that this finding that Mutaz couldn't deal with the assets of the fund as if they were his own extended only to the 1.1 million because that's what the judgment was all about. But my first point is that, of course, is not what the finding states. It's very difficult to infer a finding of something different from what the judge has said, especially on such a key issue as this. It's, of course, well established that allegations of dishonesty should be distinctly alleged and as distinctly proved, but in my submission, they should also be distinctly found. It can't be right that dishonesty can be taken to have been found by inferring matters from, as my learned friend says, across 500 paragraphs of a lengthy judgment. And in this context, I would also rely on our general ground of appeal, which is, of course, that given the other flaws in the judgment, and there undoubtedly are flaws, however one looks at it, my learned friend was forced to say in relation to the fiduciary duties owned by the individual, something's clearly gone wrong. In light of the judgment as it's presented, where there are flaws, there are findings without reasoning, there appear to be contradictions, it would be completely unsafe to assume that when the judge says one thing, he actually means another. So as a result of this, we say the judge didn't ask the right questions as to what the individual defendants believed. He didn't find that the individual defendants knew that Mutaz did not have authority to deal with the termination fee. And we also say that he gave no proper conclusion, no proper reasons, even for the conclusion he reached. As a footnote, as my learned friend would say, we do say that in that regard, if the judge were going to make a relevant finding as to subjective belief, he does need to do so, he would need to do so, in respect of each individual defendant, where obviously, where one's dealing with subjective belief, it's not enough to deal with them all together. And that is why I took your lordships briefly through some of the cross-examination extracts to show that each of the individual defendants gave evidence, both written and oral evidence, on these key questions as to what they actually believed. And if the judge were going to make a finding as to what they actually believed, at the very least, in my submission, he should have dealt with them individually and given reasons for why he did not believe the evidence they gave. Because as your lordship saw, this wasn't simply a question of a passing comment in one piece of cross-examination or something like that. It was an issue that came back again and again, their understanding of Mutaz's authority, their understanding of whether the fee would inevitably have been paid by the fund to Fimmel if it had been paid to the fund in 2017. I would like to move on now. I have a few other points. They're all rather shorter. My learned friend made a point to say that Mutaz wasn't involved up until the 19th of June 2017. But of course, the judge found that he was shown the deed of release in December 2016. That's at paragraph 181 of the judgment. And Mr. Nuseibeh's witness statement, paragraph 69, that's S324. And this is the relevant evidence, which no doubt the judge must have drawn on. But he says, I showed Mutaz the draft deed of release. This is in December 2016. I discussed this with Oumar in advance because, I showed Oumar the draft deed of release on the next day and obtained his approval for the approach, including the termination fee. I discussed this with Oumar in advance because, as always, I was unsure how Mutaz might react, and we were all acutely aware of the urgency to get funds for FAN 1. That was the aviation note that was closing on the 21st of December 2016.
Sorry, where are you reading from?
I'm sorry, this is from Mr. Nuseibeh's witness statement, paragraph 69. It's at S2324. I'm sorry to save time. I was reading from my notes. But
it's okay. So give me the reference again.
S324. In the end, I printed out the document and sat down with Mutaz to make sure he read it as Oumar advised. As it turned out, Mutaz was completely on board with the approach. He appreciated the urgency and the need to incentivize a quick deal. And also, the judge found at paragraph 194 of his judgment, he said, it's a fact that Mr. Mutaz Otaibi is not copied in on external emails with Burgess Salmon and others. This was highlighted at trial, but I do not consider it a change to any previous practice or suspicious. This is in context where your lordships may recall that the defendants gave evidence. I don't think it's in dispute that the three individual defendants and Mutaz over this period were working in an open plan office. They were meters away from each other. My learned friend suggested that why wasn't there a piece of paper? Why wasn't there some formal piece of paper from the fund authorising them to do what they did? But my response to that is to say, well, why would they need a piece of paper? If they believed, as they did, that Mutaz had authority to act for the fund, why would they say, well, we need you to write that down formally? It's not as if there are dozens of formal pieces of paper authorising all the various activities that took place over this period. We've seen the IMA gives a very general authority to the investment manager, to FIML, to act without reference to the fund. And the judge also found, and this was in respect of the document we've seen where David Whitworth signed a document in 2016 and it was merely updated rather than getting him to re-sign it. The judge found that unusual procedures such as that were, quotes, not out of the norm, close quotes, for the Floreat group. That's at 326 of the judgment. Turning to the question of the individual defendants and fiduciary duties, I just have one point to make, which is my learned friend effectively seeks to say that if you ignore the employment contracts and you ignore the contractual structure, in other words, if you ignore two of the key elements in this matter, then it might be possible to infer from other places in the judgment that there were sufficient acts from which one could deduce that the individual defendants owed fiduciary duties direct to the fund. And I would simply say to that, well, it's obviously takes one nowhere to assume a counterfactual which ignores several of the key relevant facts. And of course, the judge didn't set out and identify those relevant facts in the very place where he was talking about whether they owed fiduciary duties. So to return to the idea of the dog that didn't bark, when one is construing those paragraphs of the judgment, where in my submission he plainly finds they didn't owe fiduciary duties, if the finding had been the other way, one would have expected a series of points saying this happened and that happened on this date, they did this act, or they had that authority, or they acknowledge they're assuming this duty, but there's none of that. So there was no finding by the judge to support the various matters that my learned friends say, well, obviously this would be a fiduciary duty but for the employment contract. I don't accept that at all. And the crucial point in this, and this is the finding by the judge that of course is not challenged and was repeated again and again, is that the fund didn't delegate the redemption of the Reading loan to the individual defendants. It delegated it to FCM London. So it's not enough to say you have to ignore the employment contracts. You also would have to ignore what the judge found the fund actually did. I have a number of short points. Paragraph, you were looking with my learned friend at paragraph 362 of the judgment, which had an extract of Mr. Nuseibeh's cross-examination, and the fuller cross-examination is in the unagreed bundle U40 to 41. A DS1 form is indeed a form for a mortgagee to file to show that the mortgage has been discharged, so that's what the solicitors were holding. My learned friend says that there was no finding by the judge that the fund was unusual. But Mr. Churchill's witness statement, let's have a look at that. It is in supplementary bundle. It is at tab 24.
Sorry, that reference you just gave us, I'm not sure. So you say it's in the unagreed bundle.
Sorry, pages
362, the reference is the unagreed documents bundle.
40 to 41.
Is that internal page 40 to 41 of the transcript or bundle reference?
I think it's a bundle reference, but let me check.
I think it must, presumably must be somewhere.
I'm sorry, I'm getting lost. I'm not quite clear what we're meant to be looking at.
I'm sorry. There was a very There was a very short point. At one point this afternoon,
yes.
We were looking at paragraph 362 of the judgment, and in that paragraph, there's an excerpt from the cross-examination of Mr. Nuseibeh.
Yes.
And there's a fuller excerpt, I think, which may help to explain more what's going on there in bundle U, at bundle pages 40 to 41. I'm sorry, I haven't made that clear. My next point is the fact that my learned friend had said there's no finding by the judge that the fund was unusual. Well, that is correct, but I just wanted to show you what Mr. Churchill says about the fund in his witness statement, paragraph 22 and 24. And that's at bundle S, tab 24, page 261. In fact, I would like to take you to 262, and paragraph 24 is the key one, where he says this. The main purpose of the fund was to benefit Mutaz and Hussam. Within the fund, investors were entitled to a 5% preference dividend, and all profit above that was paid out in management fees, first to FIML and then to FCM and FMB. I understand from our legal team that Oumar will address the role of FIML and its late introduction to the corporate structure. Fees, therefore, would increase if we invested in riskier investments, but the return to investors would not. We also had the ability to charge upfront fees. These two factors combined meant there was little to no alignment of interest between the investors in the fund and the investment manager. This is the opposite of what you would see in the market for this type of investment product. By contrast, if the investments were to underperform or even lose money, it was the investors that would lose out, because the preference dividend was equity, not a coupon. If returns were ever insufficient to fund the dividend, the shortfall would be eaten by the investor. In the context of fund structuring, it was borderline absurd, as it creates a glaring conflict of interest for FIML FCM, because they're incentivized to make relatively risky investments to maximize profits and fees. The reality was, therefore, that it was only through Hussam's relationship of trust with the secret investor that the fund could obtain substantial funding. What Mr. Churchill is describing there, although there's no finding by the judge, is an inevitable consequence of this rather unusual fee structure, that the interests of the fund manager, FIML, and FCM were entirely out of kilter with the interests of the investors, with the fund itself. And although it may seem irrelevant whether this was an unusual fund or not an unusual fund, what I take from that is that the conflict of interest between FIML and the fund was baked into the very DNA of the relationship. So when one is considering fiduciary duties and whether FIML owed any fiduciary duties to the fund, it was set up in such a way that there was this very significant inherent conflict in the way in which fees were charged and the way in which investors could benefit. And it's in that way, that unusual nature of the fund is, I say, a relevant factor when one is considering how to construe the investment management agreement, and in particular, when considering whether FIML owed fiduciary duties to the fund, and if so, what fiduciary duties it could sensibly owe, given that there was this inherent conflict of interest at the heart of its relationship. There's a very short point about the role of Floreat merchant banking. There's some, I think my learned friend says this is not found by the judge. There is some submissions on there in the defendant's closing submissions at trial. It's at S571 to 572, if that is of interest. Solicitors, Burgess Salmon, I think it was suggested that at trial there had not been any reliance on the point that the solicitors were involved. We have been back to the closing submissions, and it was part of the defendant's closing submissions, and this is not in the bundle, it's at day 11, page 45 of the transcript, where Mr. Cavender, King's Counsel, did take the point that Burgess Salmon didn't raise a point on the termination fee, and yet had the opportunity to do so. As he put it, so if Zaki, Mr. Nuseibeh, made a mistake, then Burgess Salmon did too. The last of my very short points is, I think I've mentioned in opening that at trial, the defendant saw this as revenge litigation in some respect. And there's a reference to WhatsApp messages. We don't have those messages in the bundle, but just for your notes, this was mentioned in the defendant's trial skeleton at S397. I think that leaves just 2 points. One is the cross appeal, and one is the point about whether FCM owed duties to the fund. So the cross appeal is in relation to the tortious duty of care. And what I would say about this is that, of course, my learned friend has to establish either that this was the decision of the judge in finding that no tortious duties were owed was so unreasonable that no judge could possibly have made that decision, or he has to say that there's an error of law. In my submission, the only point that is really identified by the respondents is to say that the judge placed too much emphasis on the contractual structure. We looked at some cases in opening, I think there are others mentioned, that show that the contractual structure is very important when considering these matters. If a duty of care is to be imposed, at the very least, it has to be consistent with the contractual structure. And so, in my submission, even as a starting point, to say that as a matter of balancing relevant factors, there's an error of law because too much weight was placed on this, I would say that's not a very promising start for his cross appeal. And then, secondly, he relies in particular at, he would have to say that there are particular acts that the individual defendants have done that mean that they assumed these duties to the fund. And in my submission, neither in his written submissions nor oral submissions has he really pointed to the particular acts that show that the individual defendants did so. My next point is that my learned friend raises the issue as to whether FCM also owed duties to the fund. As I understand it, this submission only becomes relevant in circumstances where your lordships find that the individual defendants didn't owe any relevant fiduciary duties to the fund, and FIML, as investment manager, didn't owe any fiduciary duties to the fund. And in those circumstances, it would indeed be surprising if only the middleman in this arrangement, FCM London, owed fiduciary duties to the fund. If we look at what the judge did find, he found at paragraph 458 of the judgment, FCM did not even owe fiduciary duties to FIML. That's 458. He concludes that paragraph saying, there's no equivalent to clause 13 in the investment advisory agreement, but nonetheless, when he looks at the agreement on the duties that FCM London would owe FIML, serve the interests of FIML in good faith, discharge its obligations hereunder with a reasonable skill and care, devote such time and attention to the performance of its duties as shall be required, and so on. In those circumstances, he was not persuaded that the relationship between FIML and FCM London was a fiduciary relationship. And if one looks at, my learned friend then moves to rely on paragraph 460, and this is another one of these findings which the judge simply makes. Paragraph 460, the fund invites this finding. He says, the actual finding sought is put in terms of the funds and or FCM London's duties were breached by the individual defendants. Well, clearly the fund's duties weren't breached. So even if we silently correct that error for the judge and assume that he meant FIML, the finding sought is that FIML's and or FCM London's duties were breached by the individual defendants, procuring diverted sum away from the fund, knowing it's contractually due to the fund, and so on. And the judge simply says, I'm able to make finding 30.1. And in my submission, there are 2 points here. The first is that the finding is that only FIML and or FCM London breached their duties. So it's wholly consistent with the judge having made no findings at all that FCM owed fiduciary duties to the fund. There isn't actually a consistency here if one simply reads it that it's FIML or FCM London, and in this case FCM London doesn't apply. So that's my first point, is that the finding as sought and as made doesn't actually find that FCM London breached duties to the fund, although it is, in my submission, another example of rather curious finding focused on breach only without stopping to consider first whether any relevant duties have been found, because it's common ground between us that the judge made no findings that FCM London owed fiduciary duties to the fund. And my second point, to reiterate a common theme of some of my submissions, is that once again there's a finding but no reasoning, certainly no reasoning relating specifically as to why one or other of the relevant duties had been breached. Excuse me one minute. I think unless your lordships have any other questions, that concludes my submissions.
Well, thank you very much. Thank you both very much, and the teams behind you as well. We're going to reserve our judgments. Don't suppose that comes as much of a surprise. In due course, they will be circulated to those whose names have been given to my clerk. We will hope and expect that in the light of what we say, you will be able to agree a draft order for our approval. If you find there are points on which you are unable to agree, we will have short submissions in writing and resolve them without a hearing. I am required to draw your attention, although I expect that you are well aware of it, to the decision in Counsel General for Wales and the very limited purposes for which the draft judgment may be used until such time as it is handed down and becomes public. As you know, the court takes very seriously that embargo and would look very seriously at any breach of it. But I'm sure that won't arise in this case. Thank you all very much indeed. That concludes the hearing.
All rise.